From the time of such split, such faction shall be deemed to be the political party to which he belongs for the purposes of subparagraph 1 of para 2 and to be his original political party for the purpose of this paragraph. So, what's one thing is quite clear, that the paragraph 3 dealt with factions. An argument to say that I am the party is contrary to the constitutional framework. Because he is not the party. Because the party is registered, under section 29A of the Representation of Peoples Act. The office bearers of the party are communicated to the Election Commission. And the Constitution as accepted is the final document. He can't now say, I am the party, because the party with the Election Commission and the party with the Speaker is only the members of the legislature belonging to that political party. So you can't say, I am the party. So that proposition is unfounded in constitutional law. So I go back, to my submissions. So, I go back to my page 5. Thus, paragraph 3 as it stood, I'm sorry, you also have that?
Yes.
Thus, paragraph 3 as it stood recognized the faction of the legislature party arising as a result of a split in the political party. And, your lordships have now read all the documents. Till July the 4th, is there any reference to any split? No reference. No mention of split. With the deletion of paragraph 3 of the 10th schedule by the Constitution 91st Amendment, there is no constitutional recognition of a faction or group in the legislature party. Reference is invited to petitioners' written submissions, 160 to 163. Your lordship have it. I've given the page so that it's easy, The effect of deletion of paragraph 3 from the 10th schedule is that the Constitution does not recognize any faction, whether it consists of majority or a minority of the members of the legislature party. Why? There's a constitutional basis for that also. I tell you just why. When I seek election directly from the electorate, I don't seek election in my personal capacity. I seek election on the symbol of the party. In my activity in the House and outside the House, I continue to be a member of that party and must honor the discipline that's imposed on me. So, in the relationship between the legislature and the political party has primacy. The legislature party has not primacy. So, when you are interpreting the Constitution, you have to give primacy to that political party whose representative I am in the legislature. You can't in the process give primacy to the legislature over the political party, which the other side is trying to do, by saying, I am the party. It can be one member of legislature, but can he say, I am the party? So within the constitutional framework, the will of the legislators, in fact, is subject to the functioning of the political party, both inside and outside the House. Now, he can have dissent outside the House, but no dissent within the House, which is why the whip. Because there he represents. That's why Holohon says you can't go against it. That's the rationale for it, Malats, constitutional rationale for it. Then, Malats, a fortiori, therefore, the concept of a faction asserting itself in the legislative party and acting dehors the political party or calling itself the political party is not contemplated by the law, and any such claim will be per se fall foul of paragraph 2 of the 10th schedule. Parliamentary democracy only recognizes alliances between political parties, and not an alliance between a political party and a faction of a legislature party. That be constitutional harakiri, Malats. Reference is invited to the order for preference to be followed by the governor as stipulated. Malats, kindly have a look at that page only, Malats. Kindly come to my written submissions, page 101, Malats. Right, 101.
Which file would that be, please?
Petitioners written submission.
Yes,
Petitioners,
101.
written submissions. Page.
Yes. Now, let's kindly share. Very interesting. Yes, yes. Yeah. Kindly see page 101, paragraph 240.
Yes.
Yes. It is submitted that the governor cannot recognize the rebel MLAs and of political parties, as that would ring a death knell on the working of a multi-party democracy. The Sarkaria Commission's recommendations approved by this Honorable Court in Rameshwar Prasad also categorically emphasize the importance of sanctity of the party system and states that the governor, in arriving at a satisfaction to invite a chief minister, can only recognize alliance of parties and not an alliance of a party, in this case the BJP and rebel MLAs of another party. In this regard, para 65 of Rameshwar Prasad reads as follows. Para 4.11.04 of the Sarkaria Commission report specifically deals with a situation where no single party obtains absolute majority and provides the order of preference the governor should follow in selecting a chief minister. Now, this is final. What does it say? The order of preference suggested is 1, alliance of parties that was formed prior to the election. So parties, alliance of parties. 2, largest single party staking a claim to form the government with the support of others, including independents. Again, largest single party. 3, post-electoral coalition of parties, with all the partners in the coalition joining the government. And 4, a post-electoral alliance of parties, with some of the parties in the alliance forming a government and remaining parties, including independents, supporting the government from outside. There is no space for factions when the governor has to appoint a chief minister. Now, if all of Shivsena had gone to the BJP, governor will call for a floor test. If the Shivsena itself had gone. Now, this is cast in stone. Now an argument is being raised, it doesn't matter, and which is why, I said to your lordship the consequences of it. Supposing 2 or 3 members of each political party who don't form the majority go to the governor and say that support of 6 of these people reduces the chief minister to a minority, therefore call for a floor test. It would be disastrous for democracy. That's the Ayaram Gayavaram principle that we gave up. Would 50 members of BJP today support Uddhav Thackeray, will he call for a test? So, the whole propositions, the propositions that have been advanced by learned friends are all contrary to basic principles of constitutional law. I go back, to my submissions. So, para 20. Therefore, the recognition of a faction of a legislative party as the basis to cast a doubt on the confidence enjoyed by the government in the House would be an act of constitutional impropriety and legally mala fide. It is respectfully submitted that under the constitutional scheme, a member of a legislative assembly set up by a political party does not have any independent identity in the House. Dehors the political party on whose ticket he is elected to the House. The same is clear from the following. Now, this is important. Kindly see Article 170 of the Constitution and kindly see Sub-Article 1. Subject to the provisions of Article 333, the Legislative Assembly of each state shall consist of not more than 500, not less than 60 members, chosen by direct election from territorial constituencies in the state. Well, I mentioned that to your lordships yesterday. Delimitation Commission, territorial constituencies, direct election from the territorial constituency. Now kindly come, let's go to item 2. Under 7.1 of the Representation of Peoples Act 1950, the total number of seats in the Legislative Assembly of each state is as shown in the second schedule. Further, Section 7.3 of the Act provides that the extent of each assembly constituency shall be as determined by the orders of the Delimitation Commission made under the provisions of the Delimitation Act. I don't have to read it, your losses may take it that that's correct. We'll waste time otherwise. Then come to 4. The first step in the process of nomination, Section 33 of the Representation of People Act, prescribes that each candidate desirous of being elected to a seat is required to deliver to the returning officer a nomination paper completed in the prescribed form. The provision itself differentiates between candidates set up by a recognized political party and those not set up by the party. That's Section 33. Let's not read it. That's up. Nobody can doubt what I have said. So otherwise, it'll take time. Next, the relevant rule in the conduct of election rules pertaining to Section 33 is Rule 4, that deals with nomination papers and prescribes that each nomination paper must be completed as per the appropriate form. The appropriate form for the purposes of election to the Assembly is Form 2B. Part 1 of Form 2B applies to candidates set up by the recognized political party. Further, as per paragraph 13B of the symbols order, a candidate is deemed to be set up by a political party only if the political party provides a notice in Form B to the returning officer which contains the endorsement of the political party as to the approved candidate on its behalf. Hence, from the very initiation of the election process, the identity of a candidate for an election is as a representative of the political party by which it was set up. So the primacy is of the party. The legislature has no identity other than being a representative of the party. After the election, Section 66, 67 of the Act require the returning officer, once the counting of votes have been completed, to declare the election result and to communicate the same to the Election Commission and the Secretary of the House. That's very important, Melissa. Kindly see that, 67 of the...
That's okay. I think, you've paraphrased it and there is no reason to doubt it.
Right. The reason is, what he sends is that he has been elected as